All right, so this is our final class on the Section 5 powers under the 14th Amendment that belong to Congress, and this is actually our last class on Congress's powers more generally. So, although this material has been difficult, the good thing about these three classes is that really there's been no new material introduced since the first class. So, yesterday's class, today's class, is largely about how to apply the rule that the court comes up with in Birney, this congruence and proportionality rule. With this particular So this will be the first case that we're looking at where the court upholds a statute under Section 5, and we definitely want to keep our eye out open for what makes this case different than the other two cases. But in this lecture, let me also emphasize another aspect that we've talked about in the past, but that is worth emphasizing here, which is this idea of a prophylactic measure or a preventative measure that Congress can pass under its Section 5 powers. So to do a little bit of review, what is the enforcement power under Section 5 of the 14th Amendment? The court has described this as a remedial or a corrective power. And this is in contrast to the plenary powers that Congress has under Article 1, Section 8. So if you think back to the cases that we read under the Necessary and Proper Clause or the Commerce Clause or the Taxing and Spending Clause, Congress could create whole programs, schemes that were designed to enact brand new policy that Congress thought good for the nation. They can do that because they have plenary authority under those powers. Whereas the goal here is to merely remedy or correct violations that Congress sees out in the states of the prohibitions contained in Section 1 of the 14th Amendment. But even though this power is a far cry from the plenary powers, the court has said that that Congress is not limited to merely enforcing those restrictions. I think the court said in the Garrett case yesterday, Congress is not limited to merely restating what the court has stated is what actions are prohibited by Section 1. So the court has said that valid enforcements of the Reconstruction Amendments can prohibit more than the substantive provisions themselves prohibit. So why is this? If Section 5 says that Congress is given the power to enforce the provisions of the 14th Amendment, and it's the Supreme Court that sets out what those provisions of the 14th Amendment are, what's the theory that Congress can go beyond those prohibitions? And the court has told us, and especially in this case today, that Congress can enact these preventative or these prophylactic measures that have their eye on the end goal of preventing violations of Section 1, that is, preventing violations of the Equal Protection Clause or the Due Process Clause. But Congress might decide that the best way, the most efficient way, again, think to a necessary and proper type analysis, the best way to accomplish that protection of the Section 1 rights is to do a little more, is to not just tell a state you can't violate equal protection, but to put up some other impediments in the ways of the states to make sure that they don't violate the prohibitions contained in Section 1. Now, the Birney test that we looked at, the congruence and proportionality test, is designed to try to figure out when Congress passes that line. So here, the test is designed to distinguish between legislation that's a valid enforcement of Section 1, and therefore the court gives the green light to those types of legislation, and then legislation that impermissibly interprets Section 1 contrary to existing Supreme Court interpretation of the substantive provisions there. So the two cases that we've read for Monday and Tuesday, Birney and Garrett, both fell on the impermissible side. Both cases, the court said Congress wasn't really enforcing the provisions of Section 1, and the way the court determined that Congress wasn't really enforcing those provisions was through this congruence and proportionality test, and because the legislation failed that test, the court's conclusion was that Congress was trying to change the actual meaning of Section 1 not merely enforce it. Now, the case we'll look at today, Hibbs, falls on the permissible side. The court will tell us that because it passes the congruence and proportionality test, it's a valid enforcement of Section 1. So, again, as I mentioned, we want to keep an eye out for what it is that differentiates these cases, and it's going to, since we're dealing with the exact same constitutional rule here, the difference is going to lie in the facts of the cases, in the factual difference between the statutes, between the evidence Congress finds. So going back to that second point, though, that this idea that Congress can prohibit more than the substantive provisions prohibit themselves. So let's take a look at what the nature of a prophylactic rule is. So a prophylactic rule, then, will be something that's useful to preventing a certain evil, but not necessary to it. So here's some examples that the court has given us of past legislation that has gone beyond what the Constitution prohibits, but that the court has upheld. Right? And so we might think of it this way. In order to prevent a constitutional wrong, Congress, so that's the end. The first thing is the end, and then the means is what comes after the arrow here. So in order to prevent a constitutional wrong, which Congress has every right to do under Section 5, Congress then prohibits more than just the wrong. Right. So in order to prevent racial discrimination in voting, which would violate the Equal Protection Clause, Congress says no, states can't impose literacy tests. And although literacy tests in and of themselves are not constitutionally problematic, the court upheld this prohibition under the theory that it's going to be more difficult for a state to violate the Equal Protection Clause if it can't impose literacy tests. Or in order to prevent equal protection violations in government employment, Congress passes a statute that says there can be no practices that have a disparate impact on race. So, and here the example would be a disparate impact is simply something that that results in, let's say, more white people being hired than black people, although there's no evidence that the hiring agency was overtly or purposefully racist. So let's say that there is a test that's given that just so happens that 75% of white people pass the test and 25% of black people fail the test. That would be a practice that has a disparate impact. Now, there might not be anything unconstitutional in and of itself of giving the test, but Congress wants to make sure that states aren't hiring in a 75-25% proportion, and therefore Congress says no tests. That helps guarantee that the states aren't violating the Equal Protection Clause. So ways that Congress can focus on the underlying goal of preventing violations of Section 1 of the 14th Amendment, but in having that end in mind, the means they employ are broader than what is prohibited under Section 1. But the last 2 days, we've also looked at failed examples where Congress's legislation, the court told us in both cases, was out of proportion to the alleged wrongs. So let's take the Bernie case. Congress there said it wanted to prevent violations of the Free Exercise of Religion Clause. So in order to do that, Congress passed RFRA, which prohibits states from incidentally burdening religious practice absent a compelling justification. And then we looked at the Garrett case yesterday. Congress there wants to prevent disability discrimination, and in order to do that, they pass the Americans with Disabilities Act. The one title that was at issue there forced state employers to provide the disabled with reasonable accommodations unless the state could show that to provide that accommodation would be an undue burden on it. Now, both of these, the court said, failed the congruence and proportionality test. Why did they fail the congruence and proportionality test? Well, I think it was for a couple reasons in both cases. One, and so there could be problems on either side of the arrow here. One problem might be that the wrong that Congress is trying to prevent isn't in fact a constitutional wrong at all. And I think the court was concerned about that in both of the cases that we looked at. But then in both cases, the court said, even assuming that there is a wrong here, that Congress has a constitutional right under Section 5 to prevent, the remedy that Congress employed was out of proportion to the asserted wrong. Right? So what do we mean by out of proportion here? Let me just give you an example that, that hopefully will help to make sense of a completely out of proportion situation here. So let's say that a state is concerned about reckless driving, right? So one way, and they're concerned about reckless driving because reckless driving can lead to auto accidents, which then can lead to deaths on the road. So in order to try to prevent deaths on the road, and you can imagine, I'm just imagining a state legislature here would clearly have the right to have that as a good end goal. In fact, you would hope that every state legislature has that as an end goal. So let's say they say, in order to prevent deaths on the road due to reckless driving, we know that if you drive slower, you're less likely to be reckless. So we're going to reduce the speed limit on every single road in the state to 10 miles per hour. Because that will prevent a very legitimate legislative end. So that might be true. If you reduce the speed limit on every road in the state to 10 miles per hour, that probably would accomplish your goal of preventing deaths on the road due to reckless driving. But it seems completely out of proportion to that goal, because there are other ways that you could do so without imposing such an out-of-proportion restriction. Right? You could adjust the speed limit on various roads, matching particular road conditions. Right? So that would be an example of a prophylactic rule. You're trying to prevent deaths on the road, but you're doing it by being incredibly heavy-handed and covering, as the court would say, a very broad swath of conduct, that a lot of that conduct is going to be unrelated to the wrong that you're trying to prevent. All right, so the case that we have here on page 998, Nevada versus Hibbs. So this case deals with the Family and Medical Leave Act of 1993. The FMLA, the provision that we're looking at in the Hibbs case at least, we're going to come back to both the ADA and the FMLA with the two note cases at the end of today's reading. This provision of the FMLA entitles employees, including state employees, to 12 weeks of unpaid leave to care for a spouse, child, or parent. We're told that Congress invoked both its Commerce Clause authority and its Section 5 authority in passing and justifying this statute. We're also told that Congress, in very clear terms, over on page 999, intended to abrogate the state's sovereign immunity with respect to this provision of 12 weeks of unpaid leave. The employers couldn't take any adverse employment actions because someone wanted to invoke their 12 weeks of leave. So we see that over on page 999. This is the same two-part inquiry that Chief Justice Rehnquist applied in the Garrett case. You ask if Congress has clearly indicated its intent to abrogate a state's sovereign immunity, and we see that the last full paragraph on page 999. The Act enables employees to seek damages against any employer, including a public agency, in any federal or state court of competent jurisdiction. And so Congress has clearly indicated its intent to abrogate state sovereign immunity. So then the only question is this a valid Section 5 piece of legislation? So thinking about the prophylactic, the nature of a prophylactic rule that I just described on the previous slide, what is the theory of the FMLA here as it regards a perceived constitutional wrong that Congress is trying to remedy or correct? So we're told that the theory, that the means-ends theory, goes something like this. In order to prevent sex discrimination in the workplace, State employers must provide leave for family caretakers on a gender-neutral basis. So the idea is sex discrimination is unconstitutional as a violation of the Equal Protection Clause. Section 1 of the 14th Amendment says that states cannot deny any person the equal protection of the laws. If states engage in sex-based discrimination, that's unconstitutional. So Congress has the right under Section 5 to remedy or prevent sex-based discrimination by the states. And the way that Congress is attempting to do that here is by having this 12 weeks of unpaid leave to care for a spouse, child, or parent. So we're going to want to untangle that a little more, because it might not be obvious how this is a prophylactic remedy, a prophylactic measure that is going to accomplish that end. So once we understand what the theory is, we have to ask about each side of that arrow. Is the wrong a legitimate constitutional wrong that Congress can try to prevent? So we're going to need to know a little bit about the law of sex discrimination there in order to know whether what Congress has identified is indeed a constitutional wrong. And then if Congress has correctly identified what constitutes a constitutional wrong, what evidence does Congress have that these violations are actually taking place in the states? And then moving on to the proportionality half of the test, are the means proportional to the end or to the wrong that Congress is trying to prevent? So we're going to want to look at the form the statute takes. Is the statute out of proportion to the wrong, or is it more narrowly tailored to that wrong? So, like we did with the other two cases, we need to understand a little bit about the substantive provisions of the 14th Amendment that Congress thinks it is trying to remedy or correct. So what is the law of the equal protection of the sexes? Well, yesterday in the Garrett case, I gave you a little background on how the Supreme Court has developed its three-tiered classification for equal protection analysis. And we saw that last class, disability or the disabled were not a suspect class and therefore were not entitled to any sort of heightened scrutiny. But if you'll recall from the division that I put up on the slides last time, in that middle tier known as intermediate scrutiny or semi-suspect classifications, sex was listed in that within that tier. So as the court tells us here when they are reviewing the law on page 1000, past case law establishes that sex discrimination receives heightened scrutiny. And you can see this is the very last paragraph on page 1000, where the court cites to two cases, Craig versus Boren and United States versus Virginia. Both of these cases hold that whenever a state discriminates against an individual based on his or her sex or gender, the court uses those terms interchangeably, then that discrimination is going to be subject to what the court here calls heightened scrutiny or sometimes intermediate scrutiny. All that means is that it's not rational basis review. And because it's not rational basis review, the burden shifts to the state to have to justify that discrimination with an important governmental objective or governmental interest. Okay. So already, I asked you to keep an eye out for the differences between this case and the Garrett case. So already we have an important difference, that the classification that Congress is trying to protect is a semi-suspect classification here, unlike the non-suspect classification that was at issue in the ADA case. All right, so what evidence does Congress have that the states have engaged in sex discrimination? And this is probably where you get the biggest disagreement between the majority opinion and the dissenting opinion written by Justice Kennedy. So what is this supposed evidence of discrimination? So the court starts out by mentioning at the top of page 1001 that the court itself, as they say, until our decision in Reed versus Reed 1971, The court says that the court itself actually had not thought that sex discrimination was anything to be concerned about. So it's almost as though the court is pointing at itself as saying that we too were once guilty of sex discrimination, which certainly there's all the evidence in the world that they were. All you need to look at is a case called Bradwell versus Illinois from the late 19th century. So there's been a history then of state laws that have limited women's employment. And the court also finds that, Congress found, and the court accepts, that leave policies, that is, family leave policies, have been discriminatorily administered. And the court is glad that Congress here has some statistical evidence to back up these claims. So if you look at the middle paragraph on page 1001, the court quotes from the Bureau of Labor Statistics to show that in 1990, 37% of private sector employees were covered by maternity leave policies, while only 18% covered paternity leave policies. And then the previous year, it was 33% maternity leave, 16% paternity leave. And so the court says the conclusion is that stereotype-based beliefs about the allocation of family duties remain firmly rooted in employers' reliance on them in establishing discriminatory leave policies. That these stereotypical based beliefs, these stereotyping beliefs, remain widespread. And it's interesting just to compare this case with the last case. Here, that statistic was based on private sector employees, but the court here is willing to extend that to state-based employees because Congress found that that there's no reason to think that state-based employees were any different. So how does that theory work then, considering the goal of trying to prevent or remedy sex-based discrimination and then giving everyone, men and women, 12 weeks of family leave? And the idea seems to be this, that historically, women have been considered to be the caretakers, so this is the stereotypical thinking that the 14th Amendment is designed to prohibit when we're talking about sex-based discrimination. So women have typically been the caretakers, therefore women are the ones that are expected to take off work and to care for the sick child or the sick spouse or the sick parent, but the husband wouldn't do the same. And this statute, which gave everyone 12 weeks, was an attempt to equalize that. There's no excuse for men not taking their equal share of the family responsibilities, you could say. So that at least was the theory. Women are less likely to be discriminated against. And so the argument was that women, employers, including state employers, would be less likely to hire women because there's this stereotypical belief that women will take time off to go and care for their sick child, and the employers want someone that they can count on to be at work day in and day out. So employers might be more likely to hire a man. They know that the man will come to work regardless of whether his son or his wife is ill. But now, with this new 12-week leave policy, everyone is going to have the same amount of time. So the idea would be that employers would be less likely to engage in that stereotypical thinking, which in turn, when they're states, leads to unconstitutional gender or sex discrimination at the hiring stage, let's say. All right, so how strong does the evidence have to be? And this was relevant to the question, the quiz question that was asked during the Garrett case. So let's look at what the court says on page 1002. Essentially what the court says is the strength of the evidence is going to depend upon the ease of making out a constitutional violation, because we're looking at sex discrimination, which is in a higher tier than disability discrimination. It's going to be easier to make out the claim of constitutional violation there. Therefore, less evidence is going to be needed when what's at stake is the protection of suspect or semi-suspect categories. So let's look at how the court says that. So page 1002. where the court starts off by saying we reached the opposite conclusion in Garrett and Kimmel. Kimmel we didn't read, but that was an age discrimination. That was the age discrimination statute that Congress tried to pass. Right, so the court says, under our equal protection case law, discrimination on the basis of such characteristics is not judged under heightened scrutiny, that is, discrimination based on disability or age. Thus, in order to impugn the constitutionality of state discrimination against the disabled or the elderly, Congress must identify not just the existence of age or disability-based discrimination, but a widespread pattern of irrational reliance on such criteria. Think back to Justice Rehnquist's problems with the evidence that were presented in Garrett. Right, there were all of these instances of the disabled being treated poorly in the employment realm, but Rehnquist's point was, all that might be true, but we don't have any evidence that that was irrational treatment. The employers refusing to hire the blind might have a very valid reason for doing so, and therefore that action is actually not unconstitutional. Right? The court says here it's very different. Here, Congress directed its attention to state gender discrimination, which triggers a heightened level of scrutiny. Because the standard for demonstrating the constitutionality of a gender-based classification is more difficult to meet than our rational basis test, it was easier for Congress to show a pattern of state constitutional violations. Right? So Congress shows that 100 disabled people have not been hired, and Congress shows that 100 women have lost out on jobs to men. What the court is saying here, what Justice Rehnquist is saying, is that it's the second set of evidence is far more suspicious than the first, because all we require of the first, of the refusal to hire the disabled, is a rational basis. It's just any old reason really whatsoever. It's going to be easy for a state to do that. But if there's evidence of sex-based discrimination or poor treatment of women at the hands of state employers, now any old reason is not going to do. Instead, the state is going to have to offer up some important state interest, and the burden will be on the state in these cases. Right? And therefore, it's simply less likely that the state is going to be able to meet that burden. And so the court says, therefore, Congress needs less evidence in protecting these more sensitive or suspect classifications. Okay, so next paragraph. Stereotypes about women's domestic roles are reinforced by parallel stereotypes presuming a lack of domestic responsibilities for men. So Chief Justice Rehnquist then goes into the theory about how this statute was supposed to remedy sex-based discrimination. So why is this proportional then? Assuming that, yes, in fact, making employment decisions on sex-based stereotypes is unconstitutional, how does guaranteeing people 12 weeks of caretaker leave attempt to remedy, or how is that a prophylactic measure that addresses that constitutional wrong? Isn't that out of proportion to the alleged wrong? And here, in looking at the proportionality aspect of it, Chief Justice Rehnquist notes that this is actually quite a limited remedy. It's limited to the employment context. Right? This isn't an across-the-board statute, certainly not an across-the-board statute like RFRA was, which applied to every single state action under the sun. This is even more limited, though, than the Americans with Disabilities Act, because there, reasonable accommodations had to be made across the board, regardless of what the disability was, regardless of what the business was. Here, the remedy is simply 12 weeks of unpaid leave, and the court finds that to be a lot less intrusive into the actions of the states. Moreover, and I think this is also very important, the court says that this isn't Congress's first attempt to remedy sex-based discrimination in the employment sector. There have been past statutes, and the court points to the bottom of page 1002. The court points to two statutes in particular: Title VII of the Civil Rights Act, which prohibits discrimination because of sex, and the Pregnancy Discrimination Act. And even though Congress passed those a number of years before, decades before the FMLA, Congress still found that there was existing sex-based discrimination. And so Chief Justice Rehnquist says Congress, more leeway should be given to Congress, because what this proves is that past statutes haven't actually done the work. And that, therefore, makes sex discrimination seem like a more intractable problem, something that's really difficult to solve. And so when you're faced with a problem that's difficult to solve, Congress is going to be given more leeway in trying to come up with solutions for that problem. And I don't have a separate slide here for the dissent. You'll notice that this is a 6-3 opinion. So obviously Chief Justice Rehnquist changes his vote because he had written Garrett and now he writes Hibbs. And Justice O'Connor also changed her vote. And so you're left now with a 6-3 opinion. And Justice Kennedy's main concern is with, well, I think he has a problem both with the congruence and proportionality part of it. So he finds the evidence pretty thin, but his particular problem seems to be with the proportionality part. He calls this not a remedy, but the creation of a new entitlement program. And he has difficulty seeing how this is in fact, this prophylactic remedy is in fact narrow enough, the way the majority thinks it's narrow. But notice also, and this seems to be interesting. Perhaps some might find it a bit odd. If you look at Justice Kennedy's opinion, he says when he's criticizing the amount of evidence that Congress had and the willingness of the majority to accept this evidence, look at the bottom of page 1004 over to the top of page 1005. So he's saying the evidence to substantiate this charge must be far more specific, however, than a simple recitation of the general history of employment discrimination against women. So he says, when the federal statute seeks to abrogate state sovereign immunity, the court should be more careful to insist on adherence to the analytic requirements set forth in its own precedent. Persisting overall effects of gender-based discrimination at the workplace must not be ignored. But simply noting the problem is not a substitute for evidence which identifies some real discrimination the family leave rules are designed to prevent. So it's odd that he should invoke sovereign immunity here. Of course, we know sovereign immunity is in the background here. The only reason we're looking at Section 5 is because Congress claimed to waive state sovereign immunity. But what difference does the presence in the statute of a sovereign immunity waiver, what difference does that make to the Section 5 analysis? I would have thought it shouldn't make any difference whatsoever. Because think back to RFRA. RFRA was not a sovereign immunity case. The entity being sued there was the city of Boerne, Texas. And remember, cities are not entitled to sovereign immunity under the 11th Amendment. Only states are. States and state entities. And cities are not state entities for purposes of the 11th Amendment. So, but one would think that how you apply the congruence and proportionality test shouldn't matter with respect to whether or not a waiver of sovereign immunity is at stake. One would have thought that a Section 5 piece of legislation is a Section 5 piece of legislation, regardless of whether it contains a sovereign immunity waiver in it or not. But Kennedy seems to think that the presence of a sovereign immunity waiver in the statute should cause the court to look at Congress's evidence more closely. He says this again on page 1006, the second paragraph there. He says, considered in its entirety, the evidence fails to document a pattern of unconstitutional conduct sufficient to justify the abrogation of state sovereign immunity. So it's clear that that is on the dissent's mind, and I'm not quite sure what to make of that point. Other than it's clear that a group of justices has a clear concern about the ability of Congress to abrogate sovereign immunity. Why did Justice Rehnquist change his vote? If you look at the way that he writes the opinion, there is something to what Justice Kennedy says about the degree of generality with which Congress made its findings and the degree of generality that the majority opinion seems to accept Chief Justice Rehnquist's opinion almost reads as though, of course everyone recognizes that there's still sex discrimination in the workplace, and that's enough. But he was very unwilling to recognize that disability discrimination existed in the workplace. And at least the story that I've heard from people in the know is that Rehnquist's daughter, who was an attorney, a very successful attorney, put a lot of personal pressure on him to vote to uphold the Family and Medical Leave Act. The Family and Medical Leave Act was, I think, the first major piece of legislation that President Clinton championed and then got passed and signed. And so there were a number of politically motivated attacks on the legislation, trying to undermine President Clinton's first major legislative victory here. But apparently, Rehnquist's daughter was a beneficiary of this legislation. She found it to be very helpful. She had kids, in other words, Rehnquist's grandchildren, and she put pressure on him, explaining to him that she, as a working mother, benefited from this sort of statute. It meant her being able to take time off work without any harm to her employment, able to stay home with his grandkids. All right, subsequent cases. So what's happened after Hibbs? And we see a continued split here. So Tennessee versus Lane comes back to the Americans with Disabilities Act. Remember, the Alabama versus Garrett case only dealt with Title I, which was about employment discrimination. Title II of the Americans with Disabilities Act deals with public services access. And that was what was at issue in Tennessee versus Lane. In this case, the plaintiff in the case, Lane, was unable to access the state courthouse in Tennessee. And, of course, in all of these cases, we need to know what the substantive law is. Well, the court had previously held that access to justice is a fundamental right under the Due Process Clause of the 14th Amendment, and denials of access to justice merit strict scrutiny protection. So Justice Stevens writes this opinion, and he finds that the legislation was valid when applied to Lane's situation. And you can see that approach described at the bottom of 1007 over to the top of 1008. And this is a 5-4 opinion. Rehnquist switches back his vote, but Justice O'Connor stays with what had been the Hibbs majority. And so you get this 5-4 vote upholding Title II of the ADA as a valid Section 5 piece of legislation, allowing an individual to sue a state for damages. And what happened in both of these cases where the litigants won their Section 5 cases? So in Hibbs, the court held that a state can be sued for violation of the FMLA. The case went back for trial, and Hibbs actually lost at trial. But at least his case was heard on the merits without a dismissal. Lane, interestingly, settled with the state of Tennessee and got, if I recall from the material that I read, got almost $1 million for this violation here. All right, and then the last case, the most recent one here, in note 3 of the book on page 1008, is Coleman versus Court of Appeals. So now this comes back to a different section of the Family and Medical Leave Act. And here the court is dealing not with the caretaker provision, which allowed leave to take care of your child, spouse, or parent. This was the self-care provision, which allowed you to take leave to care for yourself if you were ill. And here, the court strikes down the personal leave provision as a valid Section 5 exercise. Because here, the court found no connection between the remedy and the alleged problem of sex discrimination. Right? So Justice Kennedy, writing for the majority here, now there had been a lot of personnel changes since 2003-4 and 2012. Both Rehnquist and O'Connor had left the court at that point. So here, Justice Kennedy takes that dissenting opinion from Hibbs and turns it into a majority opinion. Now, the section is different, and he says that although The majority in Hibbs said that there was a relationship between sex discrimination and the stereotypical thinking of woman as caretaker. But here, Kennedy says that there isn't that stereotype that exists between woman as caretaker and self-care. That self-care had not been gendered, so self-care wasn't viewed as a feminine thing. That it's only women who take time off to care for themselves. Although that was the argument that was made. So that provision got struck down, also in a 5-4 vote. All right. So I think we can, I'm going to go ahead and stop there. Again, if there are questions about any of this material that haven't been answered from the quizzes or from the emails, please come and ask them at the Zoom chat session tomorrow on Wednesday.